Land use is still the topic up for our consideration, and now we consider equitable servitudes. Now, equitable servitudes bear a striking resemblance to covenants because, here again, we've got promises relating to land. But the big difference between a covenant and an equitable servitude is equitable servitudes arise out of a common scheme or a common plan. Typically, an equitable servitude will arise out of the creation of some real estate subdivision. That's different than a covenant, which typically occurs between a couple of parties. So, an equitable servitude really is a subset of the law of covenants. But an equitable servitude is bigger than a covenant. It's a type of covenant that applies to more parcels. So, in order to create an equitable servitude, we've got to have a common scheme and notice to all of the various parties. So clearly, a subdivision would be a common scheme. And what it means, substantively, is anybody within that subdivision has got the right to sue to enforce the equitable servitude. And as the name implies, the preferred remedy is equitable relief, not damages. So here, the difference between a covenant and an equitable servitude is there's no privity requirement to enforce a servitude. That's the biggest difference. So as we consider the enforceability of an equitable servitude, we have to consider first the requirements for the burden to run and then the requirements for the benefit to run. Structurally, analytically, this is identical to the way that we consider the enforceability of a covenant. But as we see, an equitable servitude is really a little bit stripped down. There are fewer elements. And so an equitable servitude, it would seem, might be a little bit easier to prove. It's certainly very easy to understand. In order for the burden to run, we've got to have intent, we've got to have actual inquiry or record notice, and we've got to have touch and concern. Pretty straightforward. For the benefit to run, the requirements are even simpler. All we need to show are intent and touch and concern. Well, that's pretty straightforward and pretty simple. The defenses to an equitable servitude are equally simple and even more predictable. It's straight from remedies. The defenses to equitable relief most commonly include unclean hands, acquiescence, and that's basically it. That's enough to show that a party seeking equity shouldn't be entitled to equity. Laches, they waited too long. Unclean hands, they themselves have not done equity. And acquiescence, which is a fancy way of saying consent. Also, we can consider issues of estoppel, and finally we can consider changed neighborhood conditions. All of these are potential defenses to the enforcement of an equitable servitude. And I think you'll see that this is very straightforward material. There's nothing really complicated about it. We need to assess the relationship between the parties. We need to establish the theory of liability that the plaintiff is seeking to establish. Here it would be a real property theory based on an equitable servitude, and then we consider whether or not that equitable servitude will be enforced by the court. It's not complicated, but there are a number of elements to it, and we'll consider some of those elements in greater depth when we consider remedies. So the last issue that we need to concern ourselves with regard to equitable servitudes is termination. How do we end an equitable servitude? And here, a couple of these termination points are the same as they are with regard to covenants. Release and merger. Again, if all of the parties are owned, all of the parcels are owned by one party, we've got a unity of interest, and easements, covenants, and servitudes all go away when we've got a unity of interest. Finally, one other way that an equitable servitude can be terminated is through condemnation, through the act of a government. And we'll consider government interfaces with the law of real property in a moment. There are a couple of other land use issues that are well worth our consideration. They're fairly commonly tested. The first of these is a license. A license is a much less important interest than the other ones that we've concerned ourselves with. And the reason is, by and large, a license is freely revocable by the grantor. A license is not really an interest in land. It's just a permissive entry. And so a license can be freely terminated. That is, except when it can't be. And there are always specific facts present to make a mere license something that the grantor can't just tear up and get rid of. And this is where we've got a license that is coupled with an interest. In other words, something a little bit more than a mere license, or a situation where the facts require us to estop a party from revoking a license. So issues of estoppel are all the way through these issues of land use, where we have parties that are foreseeably taking action, and that foreseeability is on the part of the other party. We're going to estop parties from coming to court to try to change those relationships. Next, we consider profits. A profit is the right of a party to come on the land of some other party in order to take the subject matter. So commonly, one party will obtain the right to a profit to come onto the property of another, to harvest grain, or to take logs off the land, or otherwise to sever something from the real property in order to make money off of it. This is intrinsically related to the law of contracts, and so we have to consider both the law of contracts and sometimes real property issues in order to resolve a profits question. And that leaves us with only one final major set of issues relating to land use, and this is where the law of real estate touches against constitutional law. I've told you from the very beginning that one of the things that makes the law of real property both more intimidating than many of the other subjects, but also more approachable, is there are so many little tangents going from real property law to other laws. And here we're dealing with constitutional law and real estate. The biggest issue here is zoning. A state will rely on its police power to exercise reasonable powers over zoning to protect the health, the safety, the welfare, the morals of everybody within the jurisdiction. The state and local governments have zoning power, and so long as they exercise that zoning power reasonably, a party who is subject to that zoning law won't be able to protest it. And as we study constitutional law, we'll see issues that come right out of this part of the real property outline too. Now, suppose we've got a non-conforming use at the time a zoning law is passed. Does that non-conforming use have to change? Answer, it sort of depends on the facts. Look and see how the material is tested. Also, there are issues of special use permits and variances. Here, typically, those permits themselves are not challenged, but other parties will seek to obtain the same variance and will raise an equal protection claim if they are denied. Remember, equal protection goes to a discrimination where we've got an authority in the government with power over land who treats some landowners differently than others. There's a possible theory of liability arising out of the U.S. Constitution, namely equal protection, where one similarly situated party will demand to be treated the same way that another is. So, special use permits and variances are part of the law of real estate, and they can imply equal protection issues to the extent that a government is discriminating among landowners. So, we see that a state and local government will rely on its police power. We also see that state and local governments exercise eminent domain powers to condemn property in order to make different use of the property. And up to a point, a government does have the authority to do that. But there comes a time where government excessively regulates the use of land, and when they do so, when the government regulation becomes really an unreasonable nuisance, a party that owns that land is entitled to fair compensation. And that law arises out of the Fifth Amendment, and it's called a Fifth Amendment takings issue. And this law has become more powerful and more complicated during the last generation. It still is not heavily tested. Go forth and practice. You'll see that real estate takings issues are relevant, but they're pretty simple and straightforward. And that concludes a discussion of land use. Next, we will have a series of 3 videos on what I consider to be the core material from real property, the most important and the most highly tested material, all of the stuff dealing with real estate transactions. So here we'll deal with landlord-tenant. Remember, the National Conference of Examiners considers landlord-tenant law to be part of land ownership. I'm analyzing it with regard to real estate contracts. We will also deal with real estate sales contracts, we'll deal with mortgages, and we'll deal with titles. The good news is this material is fairly extensive, but it's not incredibly difficult.